State of Tennessee versus Billy Lynn Hollis Jr.
Yes, Your Honor.
What? We have two motions that are before the court. The first motion is for a motion to enforce an original plea offer. Second is a motion for a furlough into treatment.
Mr. Lockhart, I think they're your motions.
Mr. Lockhart, are your motions?
We call Mr. Billy Hollis.
Mr. Hollis, if you'll come up. I'm going to ask you to raise your right hand and be placed under oath. Stand up, if you will, raise your right hand, be placed under oath.
If you would state your full name for the court.
Billy Lynn Hollis Jr.
Mr. Hollis, are you in jail here in Cheatham County?
Yes, sir.
And how long have you been in jail?
About 2.5 years.
All right.
Be sure to talk directly to the mic.
And ballpark, when were you arraigned on these charges?
November 13th, 2023.
And did Mr. Scott Saul previously represent you in this matter?
Yes, sir.
And at some point in time, did he come to you with a settlement offer?
Yes, sir.
And did you appear in front of Judge Lockhart Mash on what would have been a date to enter a plea?
Yes, sir.
And what was that date?
January 14th, and then it got pushed off 2 weeks to January 28th. And that was the day I was supposed to sign it.
All right. On January the 28th, what was the offer you had at that time?
6 years community correction.
And did it require that you do anything as a condition of community correction?
Treatment, year-long treatment program.
All right. And on January the 28th, were you prepared and ready to take that settlement offer on that date?
Yes, sir.
What were you able to enter that plea on that date?
No, I was not.
What happened?
They never come and got me for court.
And did you find out why?
Not until 2 weeks later when Mr. Saul showed up with a completely different deal.
Did you find out that Mr. Saul couldn't be there on the 28th?
No, not until he showed up 2 weeks later. I didn't know.
Did you find out then why he couldn't be there?
Yeah, he told me that he had a family emergency.
Or had a family emergency or perhaps even a death in the family?
Yep.
Right.
Yes, sir.
But on the 28th, you were ready to take the offer.
Yes, sir.
And did something happen after that court date was put off in regard to your offer?
Yeah, when he showed up, the 28th, it got pushed off. I wrote the court clerk, and they said it got pushed off till June 3rd. And then on February 14th, Mr. Saul showed up and said that Mr. Arnold had left, that Mr. Stevens had gotten my case and was offering me a 25-year prison sentence.
So it went from 6 years community corrections to 25 years to serve.
Yes, sir.
And did Mr. Saul say anything to you about why the offer had jumped like that?
Just other than Mr. Arnold had left, Mr. Stevens got my case, said that he previously knew me, and since he had me here, he's going to hang me. He's going to nail me. And those was his exact words.
All right. Had you had dealings with Mr. Stevens before?
Yes, sir. We'd crossed paths in Clarksville before.
And based on the jump in the offer, what did that make you think in regard to Mr. Stevens taking over?
I mean, like a personal bias, possibly even conflict of interest. I mean, everything that, just the deal itself, from 6 years community corrections to 25 years at 100% to serve. Mr. Saul stated that, he knew me from Clarksville, and like I said, that he was going to nail me. Since he had me here, he was going to nail me. Those was his exact words. he told me before that, he's like, look, this DA hates you. You know what I mean? And I think hate's a personal thing. If you hate something, that's pretty personal. I feel like it's, being targeted for something that I'm just not getting a fair shake here. I don't think the deal was taken away from me unfairly. I was going to sign it that day, and Mr. Saul had a death in the family, or for whatever reason, he wasn't able to show up here. So why wasn't I able to sign the deal the next time? I mean, I would have signed it that day.
After the 14th, or between the 14th and the 28th, had you satisfied your mind in regard to your Montgomery County charges?
Yes, sir.
And
Yeah, they was waiting.
regardless of what was going to happen in Montgomery County, you wanted to take the offer Mr. Arnold made.
Yes, sir.
And you would have done that on the 28th
Right.
if you'd been allowed to come to court.
Right. I would have done it before. I never rejected the deal. Mr. Saul told me that the deal wasn't going nowhere. He advised me as my attorney to go to Clarksville, get them settled first, and then come back here. Once I got that done, that was in December. I got them settled. They was on board. I come back here in January, and then this one happened January 14th. They needed to know how long exactly, so they pushed it off to the 28th, and I would have signed it that day.
That was to provide time to coordinate everything.
Yeah, yes, sir.
But on the 28th, you were ready to plead and take the offer.
Yes, sir.
You also have a motion filed asking for a furlough. Have you ever been to treatment before?
Yes, sir.
And do you deal with drug and alcohol addiction issues?
Yes, sir.
And do you also deal with some mental health issues?
Yes, sir.
And what about your past help cause some of those issues that you have?
Childhood trauma. I mean, I was
Were you sexually abused as a child
yes, sir. When I was 7 and 8 years old.
when you were 7 and 8 years old?
Yes, sir.
And do you think if you had a lengthy inpatient treatment that would deal with your mental health issues and your addiction issues, that you could succeed?
Yes, sir.
And are you willing to do a 1-year-long program, whatever the court would
Yes,
see
sir.
fit?
Yes, sir.
Would you be willing to wear a GPS monitor if that was a condition of you going to treatment?
Yes, sir.
You've got a lengthy record, but you've never been able to address the mental health and the addiction issues. Is that correct?
Right.
Do you think if you could address that, it would make a difference
Yes,
in
sir.
how you behave?
Yes, sir.
Anything else you want to add to the court as to why you think you'd be a good candidate for treatment?
I just really had a lot of time to sit here and think and reflect, and I really want a chance at, changing my life and getting the help that I want and need. I never had that opportunity.
And if the court were to allow you to take the original offer, would you complete your loan program as a condition of your community corrections if you're allowed to do that?
Yes, sir.
Anything else you want to tell the court as to why you feel like you could succeed if given these opportunities?
Well, and
Nothing.
just really want a chance, please. I ain't never had the opportunity to go to rehab, and I've always just been kicked right back out into the same environment and never actually had any help.
All right. No further questions.
Stevens, you may cross-examine.
Thank you, Your Honor.
So, Mr. Hollis, you're here today asking the court to enforce your alleged prior agreement, and if the court doesn't do that, to furlough you, correct?
Yes, sir. Or do both.
Okay. Let's go over your history for impeachment purposes on both of these motions and your likelihood to appear regarding the motion for a furlough. In 2019, you pled to a diversion for 4 auto burglaries, correct?
Believe so.
Okay, so you were given the chance to have this come off your record if you were successful, correct?
Sure.
Did you do treatment during that time?
Treated.
When you were given a chance to do probation and not be incarcerated, in fact, get a diversion, did you do treatment at that time?
And I guess I went to a 28-day program, and they
Okay.
told me that that wasn't rehab.
Okay, so then
They stated that.
in 2020, while you were on this diversion, you were charged with and ultimately convicted of selling meth, correct?
No, sir.
You are convicted of a felony meth charge, possession with intent?
Sir.
Okay.
No,
So if the records show that, that would be incorrect?
for selling meth. I was never charged for selling meth. I might have got a possession charge for meth, but it was never meth in scales or anything like that to indicate that I was a dealer.
Okay, so if you pled to a felony meth charge, that would be incorrect.
Yes, I have a felony meth charge, I guess. It went to circuit court, but it was a half a gram. Anything over a half a gram is considered felony.
You were given probation for that. And did you seek treatment then?
Sir.
So that was another chance of not being in prison, and you did not seek any of this treatment at that time, correct?
I was supposed to go to treatment when I was homeless. I got kicked right back on the street. Within 3 days, I was expected to go to probation with no license, no car, right back in the same environment. I've never actually been, anybody helped get me there to the place.
That's interesting you say that. In 2021, you got in a car with Agent Matt Farrell, and when he lit you up, you took off from him at a high rate of speed, didn't you?
No, did not.
Okay. You were incarcerated a little while, and then you were released in 2022, put on probation again, correct?
It was the first time that I actually come across you in Clarksville. And I begged for treatment then, for you to send me to rehab then, and you would not do it.
Do you recall May 2022 high-speed chase you were in where an injured or an innocent person T-boned your car at the intersection of, I believe it was River Road and Dean over by Food Line in Clarksville? Do you remember that?
Who was driving?
Megan Byrne?
And I was a passenger.
Yes.
Okay.
Do you remember that?
Yeah, I remember that. This was Vanderbilt. Has 3 broken ribs and a lacerated kidney.
During a high-speed chase with law enforcement, I believe it was Deputy Thompson, correct?
Deputy.
Okay.
But I was also just a passenger.
Drugs were found in the car,
And
correct?
We'll go backwards to that thing that you said about Matt Farrell. She was my co-defendant in that case, and she even wrote a statement saying that she was the one driving in that case.
Okay. So a warrant was filed for your probation. A warrant was filed for your probation violation in February 2023, correct?
So
Did you turn yourself in?
I didn't know about the warrant. At that point, I was back on drugs
Were you going to probation as you were supposed to?
up until I started getting high again. Sir.
I'm not going to go into the charges today specifically. I don't want to talk about the facts of them. But you were found and charged with the new offenses while you were on probation. That was August of 2023 for these charges, correct?
So I got an amended warrant for that.
Yeah.
I would like to just state though, up until I relapsed, I was still going to my probation officer, even after I got into that car accident.
So if they had had a warrant in February of 2023, they would have had the chance for 6 months to serve it on you. That's your testimony?
When was that car accident?
Okay. Let me move on. So you have a history including 5 felony convictions, correct?
That's what I'm on probation for.
Or maybe actually 6. Let's see. Including taking off from law enforcement. You pled guilty, but including taking off from law enforcement, Agent Farrell in that case, correct?
That was the day that me and you went back and forth. That was the first time that I ever come across you, actually. I never heard of you.
When you say go back and forth, you mean through attorney, correct? I never spoke to you.
Right.
Okay.
Which my attorney, though, that day advised me. He said, do you know who Mr. Stevens is? And I said, no. And he said, well, he's taking a personal interest in your case.
Who was this attorney who said that?
Alexis Spada.
Okay. Let me go through this. So you have felony evading by motor vehicle charges in Montgomery County pending, correct?
There is one pending, yes.
Driving recklessly, pending, correct?
I think so.
Multiple counts of burglary pending, correct?
One count pending.
And
It is-
theft over 10,000
It's
pending.
going to be produced.
It's going to be deuced, but you have charges right now of all of those counts. Theft over 10,000, burglary, driving recklessly, and felony evading. And those are new charges still pending, correct?
they're pending, but it's already settled. I'm gonna get either furlough to treatment and community corrections or whatever. That's what I'm currently waiting for here.
Okay, and you also are on 9 years of probation out of Clarksville as well, correct? And none of that's been resolved with the courts at this time. Nothing's been entered in. You pled to nothing in those courts, correct?
Correct. We're waiting here. They keep pushing it off so I can settle this here, then go there and sign my community correction.
Since August 14th, 2023, you have had no new charges since that day, correct? That's because you've been in jail, correct?
Correct.
That's all that I have. Thank you.
Redirect. Thank you, sir. You may step down. You may call your next witness.
All right, let's unpack everything we've just seen in court because this case is a masterclass in legal complexity and human drama. From the outset, Mr. Hollis was clear. He had a settlement offer on the table, 6 years of community corrections, contingent on completing a year-long treatment program. This was a pivotal moment. If he'd been allowed to take the deal as scheduled, his life could have taken a dramatically different trajectory. But what we see unfold here is not just procedural delay, it's a chain of cascading events that magnified the stakes exponentially. First, we have the role of counsel. Mr. Saul, his attorney, had a personal emergency, which delayed the plea. That's understandable on a human level, but in legal terms, it set off a chain reaction. A new attorney, Mr. Stevens, comes into the picture and immediately escalates the severity of the case, citing personal bias and prior knowledge of Mr. Hollis. The original 6-year deal jumps to a 25-year prison sentence. That's almost unfathomable. It's important for viewers to understand the legal mechanics here. Plea deals are often time sensitive. They're conditional offers, and delays, even for legitimate reasons, can dramatically shift negotiations, as we see in this case. Then we have the psychological and human factors. Mr. Hollis is transparent about his past traumas, childhood abuse, substance dependency, and mental health struggles. These aren't just anecdotal details, they're critical because they contextualize his behavior, his vulnerability to addiction, and the need for structured treatment. And the court is faced with a tension between accountability for repeated offenses and compassion for a defendant with documented mental health needs. This is where the furlough motion for treatment comes into play. It's not just about freedom, it's about opportunity for rehabilitation. Now, let's analyze the dramatic pivot, the sudden shift from 6 years to 25 years. Mr. Hollis reports that Mr. Stevens explicitly stated, "He's gonna nail me." This is emotionally loaded language and legally raises questions about potential bias or the influence of prior conflicts. From a procedural standpoint, it emphasizes the human element in law, how personal perception, attorney conduct, and prior history intersect to influence decisions in court. The commentary here is clear. The legal system is not just black and white statutes. It's also a dynamic interplay of relationships, timing, and discretion. Further, we have a history of missed opportunities for treatment and rehabilitation. Despite previous diversion programs and probation, Mr. Hollis struggled to complete treatment due to environmental factors, homelessness, lack of support, and repeated re-entry into the same conditions that fostered his substance use. This underscores a broader societal issue. Without structural support, the system often cycles defendants through punitive measures without addressing root causes. Looking at the court's perspective, they are navigating multiple layers: prior felony convictions, probation violations, the risk of recidivism, and the mental health addiction considerations. The judge is tasked with balancing these competing concerns while maintaining fairness and public safety. The transcript highlights how Mr. Hollis's willingness to engage in treatment, comply with GPS monitoring, and reflect on past mistakes positions him as a candidate for rehabilitation, potentially mitigating long-term incarceration. In summary, this case illustrates several key takeaways. Timing in legal proceedings can drastically alter outcomes. Attorney actions and communications are pivotal, and human factors, trauma, addiction, and willingness to rehabilitate can influence judicial discretion. For viewers, it's a stark reminder that the justice system is a blend of law, psychology, and circumstance. The final ruling, once issued, will set a precedent for how missed plea opportunities, personal bias, and rehabilitation requests interact in a real-world courtroom setting. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Detail.